One of the most commonly made mistakes by advocates, especially when they are starting out in the legal profession in litigation, is something that I myself am guilty of committing at least maybe between 100 to 200 times. So, this mistake that I'm telling you about that you should be trying to avoid to the best possible extent, it is still something. If you've not even started with advocacy, I can guarantee you, you will have it happen to you at least a couple of dozen times. But the intention to make this video is so that at least you can catch yourself making this mistake, and hopefully you don't make this mistake a couple of hundred times but just a couple of dozen times. When we go to court, we are arguing a matter before the judge, who is Lord, God, everything, who is going to grant us the relief, take us to the promised land. We are severely intimidated, especially for the first couple of years of our practice. To this day, when I appear before a judge, I am always, to a huge extent, nervous, afraid about what's going to happen, what is the judge going to say, and what is going to transpire. Because of this nervousness, one thing which happens very, very often, especially with the younger lawyers who've just started out with the profession, is that they'll make their submissions. The judge is now dictating the order, but because of large courtrooms, the distance between the judge and the counsels being very, very large, sometimes the judge is just barely whispering the order. Sometimes there is a lot of hustle and bustle. Someone is, talking behind the lawyer. Because of this, the lawyer who is arguing this matter is not able to properly hear exactly what the judge is dictating as the order. And this has happened hundreds of times with me. In that moment, I'm thinking, should I interrupt the judge and ask him or her, can you please speak a little louder? Or, my lord, I cannot hear what my lord is saying while the order is being dictated. Because you are thinking, let the judge dictate their order. Why should I interfere? Ask them, my lord, what are you dictating? And then it becomes a problem, because very, very often, the for you to find out what the order says will take maybe a day or two, practical realities of life, sometimes even a week, before you can understand what exactly has been ordered. Sometimes the judge will maybe whisper the order to the stenographer and then tell you, this is what I've ordered, maybe in a half a sentence. A lot of times, there is something crucial which is needed to be done, and then you are not aware, you are afraid to ask the judge, and that is why you keep quiet. Then you come out of the courtroom and then you realize, oh my god, I don't even know what the order sheet says. I had to take prompt steps depending upon the outcome of today's hearing, and then you go back and then you struggle with the situation. This is something that is almost inevitable because of all of the things which keep happening from time to time. I remember, in fact, perhaps about 3 or 4 months ago, again because of a situation where a lot of hostilities were there between the parties arguing the matter, and between all of these things that were transpiring, and I was also having a discussion with my colleague about the situation while the order was being dictated. I also forgot to pay close attention to exactly what was being dictated. So I am also prey to this situation from time to time. However, it is always a good idea, if the judge is dictating the order immediately in front of you and you are not able to hear what the judge is saying, you apologize to the judge. You say, my lord, I'm very, very sorry, but I'm not able to hear what my lord is saying. And in order to assist the court, just in case some maybe wrong averment is being noted, some averment that I made is being wrongly noted by the court, or maybe there is some fact or figure which needs to be corrected, if that is needed to be done, I could assist my lord with this. Another aspect is, you could just say to the court, my lord, there is a lot of hustle bustle in the background, and there's this huge distance between the seat of my lord and where I am standing. Could my lord just be a little louder, right? When you say this, it is embarrassing. The judge is also a little irked, but it is very, very important that you do this, that you do not go in cluelessly, because maybe the judge, what is dictating, is not accurate about the averments that you made, or the submissions that you made before the court. Maybe something else that has been said is being recorded differently. Maybe the facts as they truly are, something has not been recorded by the judge, which is of very, very huge importance if you need to appeal the matter. Or if you have a favorable order, the other party is going to appeal this, some point which will help you get their appeal dismissed. That should be included. These are all things you will only be aware of only if you know what exactly the judge is, dictating in the order. And for these reasons, it is very, very important that no matter what, you understand exactly what is being dictated by the court. And two, if you are not able to hear what the judge is saying for whatever reason, sometimes a lot of lawyers, because of their, sometimes they're screaming, sometimes a lot of them are old, they're not able to hear what the judge is saying. It is better to just, admit that you're a buffoon who's not able to hear the judge and request the judge to be a little more audible while dictating the order. It helps you in a bunch of ways, and it ensures that there is no sort of confusion, no ambiguity in the court order, and that you are also immediately up to date so that you can tell your client, your senior, your colleagues about what transpired in the matter.